So, Ms. Reddy, could you probably give us an estimate or a prediction of how many family-sponsored or employment-based immigrant visas from the USCIS and the USCIS and the DOS will use in the fiscal year 2023?
Yeah, 2023, DOS currently estimates that there will be a total of 200,000 employment-based numbers. This is due to unused family-based numbers from this year that will be falling into the next year. Next year starting in October. The fiscal year, as you know, starts in October. So we have this year 60,000, not 140,000 like we had last year, because we know that Department of State, the consulates has been doing a better job of using the family-based visas and approving more cases. So this year we only have, a less number. We have 60,000. So they've added that, and so they give it a grand total of 200,000, as opposed to last year where they had 281,000. So that's the number of total number of employment-based limit. That's a total employment-based limit for for next year, 2023. And USCIS continues to say that they're committed to using all those numbers like they did this year. They did a pretty good job of using all those numbers. It's difficult to say how many numbers. USCIS has said that it's difficult to say how many numbers have actually been used at any given point of time, because there is no single database which gives it. They're separate databases and they give incomplete information. So there is USCIS's publication of the quarterly reports, but that doesn't include the visa issued at the Department of State. And so, it's an incomplete picture. So every quarter, it's hard for anyone to look at some statistics and see where they're at and how many cases, how many numbers they have left.
Right. If, let's say, in a particular employment-based category, some visas are not required, would that mean that they can be made available in other employment-based visa categories?
Yes, absolutely. So Congress has established a statutory provision that allows for the flow of visas from one category to another. So therefore, but there's only the flow works only one way. So, for example, visas not required in EB4 and those visas, unreserved visas that are in EB5, are made available first to EB1. And then if visas are not required in EB1, they're made available to EB2. And then from EB2, if they're not used, they're made available in EB3. Now, if they're not used in EB3, then there's no way of using those EB3 visas. They don't again go back to EB1 or to 4 or 5. With EB5s, not all visas that are not used go into EB1, because for EB5 they were able to establish a law which allowed them to use the unused visa numbers from the previous years, some of them at least, into the following year. But they haven't done that for EB1, EB2 or EB3. But they've done that for EB5, lucky for them. And so not all the unused visa numbers from EB5 fall back into EB1. Some of them do. So that's how the pattern is, from EB4 to EB5, EB5 to EB1, and then 2 and 3. And then from 3, they don't go anywhere. So they're pretty much, they're wasted.
So does retrogression affect a person's priority date or place in line for an immigrant visa, Ms. Reddy?
So first of all, to understand what a priority date is, if a person files a labor certification from the Department of Labor, then the priority date is generally the date that the Department of Labor accepts that labor certification. So in some other employment-based categories, the priority date might be the date that the USCIS accepts the underlying immigrant petition, such as an I-140, if there is no labor certification. So in general, retrogression does not affect your priority date or your place in line. Your priority date remains the same no matter what. So it doesn't affect your place in line, nor does it affect your priority date. You will still receive the visa whenever it becomes available to you based on that priority date. So the priority date will keep changing, but your priority date will never change, but obviously the Labor Department will, or rather the USCIS or Department of State will announce which priority date they're working on, right? So the visa bulletin dates keep changing depending on what is the supply and demand, but your date does not change. So retrogression simply means that due to statutory limits in the number of green cards that can be issued, um, if so basically there is a limit in that, and therefore um, the Department of State will decide what date to put as the cutoff date. So that's why retrogression happens. But to answer your question, no, retrogression doesn't affect your place in the line, nor does it affect your priority date.
And what about when a category is retrogressed or a final action date is applied? What is a person's path forward to a green card, Ms. Reddy?
So when a visa becomes available to you in the future based on a final action date, um, USCIS will be able to adjudicate the adjustment of status application. They won't be able to adjudicate it as long as your 485 is not available. The priority date is not available. So what will happen in the meantime is USCIS will continue to work on your 485 application. They'll continue to make sure that all the documents are, it's complete document wise. And also it will continue to process your benefits that people usually get while their 485 is pending. So even though you may not get the actual green card, USCIS will continue processing your case, will look at it, will make sure that it's approvable so that when the dates become available, then it's easy for them to issue the approval, and they will give you benefits, or they will process the benefits. For example, you can continue to apply for employment authorization. And if that employment authorization is granted, you can work for any employer, as you know. And usually the EAD is given in increments of 2 years. You may apply for advanced parole, which again, if granted, authorizes you to travel outside the United States during the validity of that advanced parole document. And upon a return, you will be able to continue to live and work in the US without abandoning your adjustment of status application. So advanced parole acts like a visa. It allows you to travel outside the country and come back without having to go to the consulate and applying for a visa. But you have to make sure that it's valid and travel only while the advanced parole is valid. Also, you may request for porting AC-21. So if your I-485 is pending for at least 6 months, 180 days to be more accurate, and if your I-140 is approved, then you can ask USCIS to adjudicate an AC-21 application by filing a 485J. In this, you're basically saying that you're transferring your employer and that the qualifying job or the new job offer is similar or same to the job that on the basis of which you filed your green card. So that benefit is also available for you while your case is retrogressed. Also, your children who have applied for adjustment of status as derivative beneficiaries might not age out of eligibility to adjust. So your children can, as long as your children applied when they were under the 21 based on final action dates, if your final action date then retrogresses, your child will not be affected, and they will be continue to be treated as if they're below 21, and they will get their green card along with you. Of course, there are many scenarios in this, and CSPA is a complicated subject, but in general, if they apply based on the final action date, their age is frozen. Also, while you have a 485, you're considered to be in a period of authorized stay, and you don't accrue any unlawful presence. So even if while your application is pending, even if your non-immigrant status should expire, you're still allowed to live, work in the country without accruing any unlawful presence. So these are all the benefits that you have, and all the benefits that are given to you while your 485 is pending, even if your case is retrogressed.
So, Ms. Reddy, when is the derivative child's age, applicant age logged under the Child's Status Protection Act, and and how is that age calculated?
Right, we touched upon that a little bit, but
Yeah.
in employment-based preference categories, a child's age under the CSPA is basically the biological age of the time, biological age of the child at the time of visa availability, less the amount of time that the underlying petition was pending. So to give you an example, if your child was 22 years old at the time that your final action date became current and you filed your 485, then you can deduct the amount of time that your I-140 took to get approved. So say your I-140 took 1 year to get approved, then your child's age becomes 21 because it's 22 minus 1 year for the time that the I-140 was pending. So your child will be treated as below 21 and will be able to then file the adjustment application along with you. But you have to make sure that once the date becomes current, say they don't file immediately because they're outside the country or due to some other reason, the child's age is still locked, but they have to file within 1 year, the date that the visa is available. So again, CSPA is a whole subject on its own, but in brief, this is what CSPA means, and this is how a child's age is calculated.
So, Ms. Reddy, what if a person's applying for adjustment of status? Should they submit their I-693 with their I-485?
So 693 is medicals, and a lot of people have this question because especially if they're refiling or they're filing in a rush because, dates are always moving back and forth, and sometimes you just have a few weeks to be able to file because the next month then the dates retrogress. And it happens very often. It happened in October 2020 as well. So during those times, people generally, the tendency is they try to file without the medicals because, one is because of the time factor and the other is a cost factor. And also because, sometimes USCIS asks for medicals again, even if you have submitted your medicals. So, but I would encourage everyone to file their 485 along with their medicals, and USCIS encourages this as well. For the simple reason that if you do so, then that will help the need for USCIS to send out RFEs, and that will then reduce the processing time and will allow USCIS to use all the available visas. So imagine your date becomes current and it's current only for a month, and your application is incomplete, then USCIS will send out an RFE. And even if you respond to the RFE the same day, USCIS will not process the case the same day. And what might happen is then your case may not be documentary complete for USCIS to actually approve it and, reserve a visa number for you, and you might lose that opportunity when your date becomes current. So important to send not only the medicals, but make sure you send all your documents and send out a complete application so that, there's no issue with your USCIS taking more time to adjudicate your case or sending out RFEs.
Ms. Reddy, how does the transfer of underlying basis request process work?
So USCIS has created a centralized location for the receipt of, if you're asking for an interfiling case. Let me just pull back a little bit and explain to you what transfer of underlying basis is. So it's also called interfiling or transfer of underlying basis. So interfiling is a more commonly used term. And basically we're saying that USCIS is saying that if you have two I-140s, then you can ask USCIS to adjudicate your pending 485 based on the I-140 that has the best priority date. So if you have an EB3 but you also have an EB2 and both are valid, then you can request USCIS to use your EB2 I-140. And they've created a process for this. Before it was just a letter. Now they're asking us to send the form I-485 supplement J. And they have a centralized location to send this to. So you have to send it to US Department of Homeland Security, USCIS Western Farm Center, 10 Application Way, Montclair, California. So they're asking you to send your applications to this address. You should only send, again, there are two different addresses to send it to. In some instances, most instances, you have to send it to this address. But in some other instances, it could be that you have to send it to the office which is adjudicating your 485 application. So if there's no 485J supplement included, then you should most probably send it to the office where your 485 application is pending. Otherwise, you have to send it to the California address, which I just said.